Hi, this is Josh Blackman. I'm the president of the Harlan Institute. Welcome to the 2020 Harlan Institute Ashbrook Virtual Supreme Court Competition. This year, we are mooting the case of Torres versus Madrid. We're very honored to have our next match in this competition. Today, we'll be having Cameron Rose and Nathan from Arizona. And we'll be having Avery Rose and Brooke Sanchez from Texas. And they'll be going against each other. Petitioners, you have 15 minutes. You can begin whenever you're ready. Or 10 minutes, I'm sorry. Begin whenever you're ready.
Mr. Chief Justice, and may it please the court. An attempted seizure is a seizure within the meaning of the Fourth Amendment. Officers Williamson and Madrid seized petitioner Roxanne Torres the moment they shot and hit her with the intent to restrain, although she still managed to flee the scene. The common law of arrest states that an arrest occurs on two occasions: when a suspect submits to police authority and their freedom of movement is restricted, and when there is an apparent application of physical force with the intent to restrain. In this case, the latter was used to seize Ms. Torres. The officers shot at the petitioner 13 times, hitting her twice in the back. This use of force shows the intent of the officers to restrain her with physical force. The case California v. Hodari D. 1991 upholds this common law definition of arrests. In this case, Justice Scalia stated in the majority opinion that, as used in the Fourth Amendment, a seizure, when applied to a seizure of the person, referred to an arrest. He then states that, at common law, an arrest could be effected in only two ways: either by physically grasping the person, the slightest touching would suffice, or by the person's voluntary submission to a show of authority. This assertion allows the common law definition of arrest to be applied to a seizure under the Fourth Amendment. Upon further research, we are prepared to argue that not only did a seizure take place but the moment that the bullet struck the petitioner, but also that the lawfulness of this seizure must be questioned. The violation of Ms. Torres' 14th Amendment rights, which includes equal protection under the law and due process, has also come into question in this case. The seizure of Roxanne Torres was unlawful. An officer must have probable cause, a search warrant, or reasonable suspicion in order to stop and search a citizen.
Okay, Counselor, if I could just interrupt you for a minute. We're talking about Hodari D. and Justice Scalia's opinion. What exactly is the holding of Hodari D.?
The holding of Hodari D is that the seizure took place when the officer made physical contact with the suspect Hodari, and not when the officer began to chase Hodari.
So is this case controlled by Hodari, or do we need to sort of extend that precedent?
This case is definitely controlled by Hodari, and it is the most applicable case in this situation.
Okay. And Counsel, let me ask you another question, please. You talk about the common law. What is the strongest authority you have in the common law to support your position?
The strongest authority that we have in common law is a quote from Justice Scalia in the case of California v. Hodari D, where he says that
Justice Scalia is old, but not that old. Maybe a little bit older than Justice Scalia. Maybe going back to England in the 1800s or 1700s.
So in the 1700s, we had the case of 1604, Countess of Rutland, where a mace was used to seize someone. And that mace was determined to be the point of physical contact. And that was sort of the first case that we can see this definition of seizure being used.
Okay, and so what exactly is a mace? Just help us out here.
A mace is sort of like an axe in a way.
Okay, yeah, like medieval times, right?
Yeah,
so
exactly.
Let me ask you a question then. Is there a difference between striking someone with a mace versus firing a gun from a distance? Is there a difference that you see?
No, there's no difference because both can be used as deadly force.
Okay, you may proceed with your argument, counselors.
The Supreme Court held that searches that do not comply with this process violate the Fourth Amendment, as made clear in Katz v. United States, 1967. Seeing as the officers failed to comply with this process, they violated the Fourth Amendment rights of the petitioner. Ms. Torres was sitting in her vehicle when officers Williamson and Madrid approached her car and made an effort to open the door without warning or announcement of who they were. They attempted to enter her vehicle without probable cause, a warrant, or reasonable suspicion, making this act a violation of the petitioner's constitutional rights. Torres drove away in response to this, and the officers shot at her multiple times, hitting her twice. When the bullets hit her body, the officer seized Roxanne Torres before she was given the due process that the 14th Amendment guarantees her.
Counsel, can I ask you about that? Because that's actually something very interesting that I heard in your opening argument. And now I hear you asking it again. And I just want to better understand where you're coming from. You mentioned equal protection and due process. Can you elaborate a little bit more about how the 14th Amendment is implicated in the facts in this case?
So because of the definition of the common law of arrest and therefore the definition of seizure in California v. Hodari D, we can determine that the seizure occurred at the moment that Roxanne Torres was struck. Therefore, she didn't get any due process rights because they did not have any reasonable suspicion or evidence to shoot her or seize her. So
and I'm just curious because that's such an interesting argument, and I like how you're making it. So I'm pushing because I think that's a really interesting thing to think about. I like how you've couched that in the Fourth Amendment, right? The seizure question. But as to equal protection, let's even focus just on that. Where do we see an equal protection issue here?
The officers were not at the scene for Ms. Torres specifically. They were at the apartment complex looking for another suspect, and they were not there for her, and they approached her going to the person that they were actually supposed to go and arrest or seize.
So if I can elaborate, you think that they treated her equally in some way because they were going after person A, but they found her instead. Is that sort of your argument?
Yes, that is a sort of our argument.
Okay.
They were going for somebody else, and in turn, when they went for her, that just denied her the equal protection.
Because they got the wrong person, basically.
right, they didn't have any warrant to seize her, and she was not granted any equal protection because they did not give her the due process that she was granted, that she should have been granted by the 14th Amendment, as well as the equal protection.
And her Fourth Amendment rights were also violated because there was no reasonable suspicion, probable cause, or warrant for her arrest, and that violates her Fourth Amendment as stated in Katz v. United States.
That's very creative, tying together equal protection in the search like that. It's very, very creative argument. If I can ask a follow-up, let's go back to the Fourth Amendment. Do you see a difference between the phrase arrest and the phrase seizure? Are those the same thing in your minds?
So there is actually, when referring to the seizure of a person, that does count as representing the common law of arrest. Justice Scalia in California v. Hodari D actually stated that, I'll find the exact quote really fast, my apologies. He says, as it used in the Fourth Amendment, a seizure, when applied to the seizure of a person, refers to an arrest. And that was actually decided in the case of California v. Hodari D before he gave the definition of seizure. So based on that quote and based on that interpretation that Justice Scalia provided, we have determined that an arrest and a seizure, when referring to the seizure of a person, are equivalent.
Can you seize a document or paper, as the Fourth Amendment calls it?
Can you seize a document? Yes, you can seize a document under the Fourth Amendment.
So if I shot a piece of paper with a gun, right? I took your diary and I shot your diary, right? Would that be a seizure of the diary?
No, it wouldn't be a seizure of the diary because he says specifically the seizure of a person is equivalent to an arrest.
Okay. So
Definition applied to a person.
Let's go back to some of the cases you've discussed. So what are some of the other cases that you think support your case from the English common law?
So one of the other cases that we believe supports our decision here is particularly the decision that was sort of decided in Broward v. County of Inyo. And this one was kind of my apologies. In this case, the Broward really focused in on the intent of the case. And so the respondents actually were trying to use Broward to support their argument because in that case, they said that only the government determination of freedom through means intentionally applied is a seizure. However, I believe that this definition supports our case because intent was the focus of this case, not the actual termination of movement. And the termination of movement just sort of happened because he died in this situation. So they really weren't focusing on the termination, but rather the intent. And that is something that we have incorporated into our definition of seizure is that intent. So for this reason, we believe that the decision in Broward is actually supportive of our definition.
And Broward actually occurred 2 years before California v. Hodari D, and it shows that the definition of seizure has evolved over time. And they use the definition of seizure in Brower versus the County of Inyo in the common law definition of arrest that we use in our case. And that just goes to show that the definition of seizure evolves over time. And 2 years later, it was incorporated into the common law definition of arrest.
Okay. You have 20 seconds left. Anything remaining, Counselor?
No.
Okay. Very good. Thank you so
Thank
much.
you.
Okay. Could the respondents please come on camera? And you have 15 minutes whenever you're ready to begin. Okay. Whenever you're ready.
Good evening, Your Honor. My name is Brooke Sanchez, and I, alongside my co-counsel,
Avery Rose.
represent the respondents. Now, the question presented is whether an unsuccessful attempt to detain a suspect by the use of physical force is a seizure within the meaning of the Fourth Amendment, or must that physical force be successful in detaining a suspect to constitute a seizure? And the answer to that question, Your Honor, is no. Now, a summary of our argument. The unsuccessful attempts to detain the petitioner by the use of physical force is not a seizure within the meaning of the Fourth Amendment. This court should see to the public meaning of seizure throughout history. A seizure requires restraint of one's freedom of movement, as adopted in Terry v. Ohio, Brower v. Inyo, Brinlin v. California. Though officers Madrid and Williamson succeeded in hitting petitioner, they failed to restrict her movement in any way. Not for a moment did she stop, slow down, or otherwise change her movements. Petitioner reliance on dicta from Hodari does not determine this Fourth Amendment question, nor does their reliance on common law. American jurist interpretation of the Constitution has diverged from common law to the point where it's only used for guidance. Finally, ruling in favor of the petitioner will set a precedent that overburdens the American legal system and unnecessarily and unproductively diminishes the quality of police work.
All right, Counselor, very good opening. Let me, if I can just drill down to a few of the things you said. Why was the discussion from Justice Scalia's opinion Hodari dicta rather than holding? I want to drill on that for a minute.
Well, Your
Well,
Honor,
sorry. You go ahead. Go ahead.
Well, Your Honor, in regards to a submission to authority, that is what the Court of Hodari seems to have founded of the word seizure. It encompassed it into the common law definition of arrest. But if this court is familiar with footnote 2 in Hodari, it states that neither usage nor common law tradition makes an attempted seizure a seizure. And with that, we distinguish the circumstances in our case today with common law arrest, seeing as the gunshots were an attempted seizure to stop Ms. Torres.
Okay, so and Avery can answer this one if you like. I appreciate you guys are in Zooms. I know it's hard to often hand to the other one. Let me ask this question. Do you put much weight in the fact that they shot her, but she didn't go down? In other words, it was an unsuccessful attempt to seizing her, that she kind of got back up and drove for an hour?
Well, yes, Your Honor, she was fired on, but as you said, and as we all know, the bullets did nothing to stop her. They did nothing to restrain her movement. And in fact, she continued on several miles. She ended up stealing another vehicle, and she ended up far from the place where she was, where the original attempt to seize her began.
So Avery, let me ask you a question, please. You know, not everyone's so smart. You know, what happens, like, you know, not everyone's Chris Hemsworth or not everyone's Thor, right? You know, what if you have some, you know, like Bruce Banner, right? You know, some little meat guy, and he gets shot and goes down with, you know, like most people, they get shot, they go down. Doesn't your test depend on people being super strong, right? Is that really your test? You have to be super strong to not have a seizure?
No, Your Honor. I'd say that our test depends on not super strength or anything like that, but rather on if the attempt is successful. So yes, if you have a smaller person and they end up going down, then that is absolutely a seizure. But if you are using a weapon, perhaps that has no impact on actually trying to stop a person, or if that person is in a state where they are, you know, impervious to those weapons, then it cannot be a seizure because you have not stopped that person.
Okay, let me ask a question.
Only attempted to stop them.
Let me ask a question maybe for Brooke. But what about the case of the mace that your friend the other side used? Kind of, it's like these medieval axe things, right? Is touching someone with a mace sufficient to have a seizure?
Well, Your Honor, if you look at that case, it is whenever he said specifically, you're under arrest. And he did, in fact, touch the person, but you can see that more as a show of authority case more than a physical force case. So show of authority and submitting to that authority is then a seizure. And that should be no different than a physical force case. If you use physical force, no matter how strong the person is, no matter how strong the physical force is, if that person does not in any way for a moment stop and submit to the officer, there is no seizure.
Thank you. And other Justice
Can we
Rihanna?
and since we're in, no, this is great. And since we're in medieval times, I'm actually curious about a few things myself. You cite to the writs of assistance in your brief. I think that's a brilliant thing to do. Can you tell me a little bit more about how the writs of assistance and the way in which that forms the legal arc of history that comes to be the Fourth Amendment maybe influences the way that we should look at this particular fact pattern per your arguments?
Sure. Well, Your Honor, the writs of assistance were very much a common law construction designed to give broad discretion to investigate and take control of people and their possessions through general warrants. Now, the outrage and vitriol for these general warrants, they weighed heavily on the minds of the founding fathers and of many English scholars of that time. So when the time came to actually, draft a Bill of Rights, protecting the individual liberties of Americans, the founding fathers made clear their intention to eliminate that. This can be seen in the New York Ratification Convention debates and proceedings, and also in state constitutions long before that. So the final product, what we have as the Fourth Amendment, outlaws the use of the general warrant while promoting the special warrant, which specifies the time, place, and manner by which a search and seizure could be conducted.
So you would agree that the Fourth Amendment is a limiting clause, right? Based historically, that it seems to be a limiting clause based on how I think there were 5 states with state bills of rights regarding searches and seizures based on the writs we were just talking about. So help me understand this fact pattern then, because your argument when it comes to looking at a limiting clause is that, yes, you can shoot somebody, but if they can keep going, that's not a seizure. I want to understand that a little bit more in the context of the history of the Fourth Amendment.
Well, Your Honor, the Fourth Amendment is not to have been expanded upon as Petitioner would like us to do. They want to incorporate a mere touch and a mere grasping, whether or not that they leave or not. This is expanding upon the true meaning of the Fourth Amendment.
But counsel, let me just ask and push a little harder, because this isn't a mere touch. This is being shot and then driving away. There's a bullet in a woman who then is driving a car I think 75 miles or something along those lines. So can we not draw that distinction between the mere touch and the harm that comes from being shot with a bullet?
Well, yes, Your Honor, we can. That touching and shooting somebody is in fact a very big distinction, but the level of physical force is not our concern. It is whether or not a seizure actually took place. It's whether or not she was detained, whether or not that she was in the possession of the police officers, and if she was not, she was of her own free will to leave.
Well, maybe I can build upon that. Let me give you a hypothetical, right? Let's say that instead of shooting her, they realized she was going down the highway at 75 miles an hour, and they called ahead to another cop who built a roadblock, who put those cement barricades in the middle of the road. And it's at nighttime, it's dark, and she doesn't see it. And she slams into this barricade at 75 miles an hour, right? She just couldn't swerve out of the way. Now, they didn't touch her. They just put a barricade in the middle of the highway where she was driving 75 miles an hour. Is that a seizure with your definition?
Well, yes, Your Honor. And the scenario you were talking about, it's very, very similar to, I believe it's Broward. So in Broward specifically, the court decided to affirm the definitions that were provided in earlier cases, such as Terry v. Ohio, and revised the definition to a violation of the Fourth Amendment requires an intentional acquisition of physical control. So we're not arguing that if the person were to, that again, the facts of Brower are incorrect. We're actually arguing quite the opposite. We are arguing that Brower and that the definition from Brower is what controls in this case rather than the dicta.
But let's say that again. Again, so my hypothetical, the person slams into the barrier, crashes her car. Somehow Superwoman gets out of the car, starts running away on foot. Is there a seizure there? Does that, in other words, is she seized if she can get out of the car? But if she can't get out of the car, she seized, but she gets to the car as it goes on foot. Is there a seizure? I mean, where do you find a seizure there?
Well, she is seized actually, because what happens is that the vehicle that she is in, her movement is terminated essentially. She can now, she can no.
She starts running. She's running out the door.
Well,
Well, Well, Your Honor, in Brower v. Inyo, a specific quotation is whenever an officer restrains the freedom of a person to walk away, he has seized that person. And if she can't, by means of a car, get away and she is successful on foot,
she's not seized. Yeah.
Yes. Yes.
Right. Justice Rihanna, I think you have a...
You know, I'm so curious because I don't necessarily disagree, but I really want to push down on this point because I think this is important. The idea that a seizure can only be successful, do you find that outside of just the case law that you've cited?
Yes, Your Honor. It's also been in dictionary definitions throughout history. So we have Noah Webster's original American Dictionary of the English Language, and even John Bouvier's Law Dictionary during our country's early days, all the way up to the 11th definition, the 11th edition of the Merriam-Webster and Black's Law Dictionaries. All of them point to a seizure having to be, or an attempt of a seizure having to be successful in order to be an actual seizure.
And Your Honor, if I may add, even in Hodari D, they give a specific maritime law definition of a seizure where a warship still fleeing after being hit is not going to be claimed as a seized war prize. So this definition of a seizure is not only here in the United States, but maritime law.
So, Counselor, maybe we can just bridge. How do we go from maritime law to the law of criminal law? I mean, I get the analogy you're drawing, but is that the same thing, seizing ships at sea for prize versus, shooting at a woman in her driveway?
Well, the comparisons are analogous. They are both about attempting to take control of a vessel, or in our case, a person, and being unable to do so cannot constitute an actual taking control of. These possessions, in the case of the warship, are still free to they're still free to move on. In our case, the person, Ms. Torres, was still able to move on. In fact, she went 75 miles beyond the original attempt. So the comparison it's very similar in that, as I said, it's attempts to do something and failing to actually achieve their goal.
But counsel, would it have anything to do with how writs of assistance were originally determined and used when it came to customs? And that's in many ways a bridge that comes because that's what they were for. They were even before they were implemented by the Townsend Acts, et cetera, et cetera. When you see them in the 1600s in Britain, it's a customs act. It's a customs writ essentially. Is that the bridge?
Yes, and the fact that the Fourth Amendment is a direct response to the writs of assistance. So in maritime law during that time, as you said, the common law was to, if you placed your hand on it, or excuse me, rather, if you took control of that vessel, it was taken over. So in connecting all the way up till now, in today's case, the comparison, the analogy is put together through all of the historical evidence, such as the writs of assistance that bridged together both the maritime law in that time and the Fourth Amendment in our time now.
Okay, about 30 seconds left. Want to wrap up, counselors?
Yes, Your Honor. Now, ultimately, an attempt to detain a suspect by the use of physical force, it must be successful to constitute a seizure within the meaning of the Fourth Amendment, as both plain definitions of the word and existing case laws such as Brower have suggested through our history. Furthermore, petitioners' heavy reliance on Hodari D and common law arrest cases is misguided. With that, we pray that you find in favor and affirm the lower court's decision. Thank you.
Okay, right on time. Thank you, counselor. All right, 5 minutes for petitioners rebuttal. You can begin whenever you're ready, and come back on camera, and Avery and Brooke off camera, please. Thank you. All right, whenever you're ready, counselor.
May it please the court. Under the Fourth Amendment, an attempted seizure is a seizure. According to the common law definition of arrest, an arrest occurs on 2 occasions: when a suspect submits to police authority and their freedom of movement is restricted, as the respondents say, and when there is an apparent application of physical force with the intent to restrain, as seen when the officers shot and hit Roxanne Torres 2 times in the back with physical force and with the intent to restrain. The court should move to include this common law definition of arrest and evolve the definition of arrest in order to fit this situation and in order to encompass these situations that will come up in the future.
Now, the respondents in their argument stated that the public meaning of seizure should be used to determine what seizure should mean when interpreting the Fourth Amendment. Now, this is not what we should be using to interpret the Fourth Amendment. Instead, we should be using the interpretation of the founders. Now, the founders would have wanted to interpret the Fourth Amendment to protect British control. And in England, the debt collection practices where officers could reach into windows and collect debt from people without any warrant or reasonable reason to do so. So,
can I ask you what you feel then the role of stare decisis would be in this case? Yeah, I'll go with that.
This would be, can you define stare decisis for me? I apologize.
Sure, it's following legal precedent to this day.
Right, so that would be California v. Hodari D, because California v. Hodari D provides us the definition of common law of arrest, which is reflective of what a seizure should be used to interpret.
Okay, can you proceed, counselor?
Now, the interpretation of the founders would have been to protect the rights of the individual. When a search occurs of a house, the illegal search would occur the moment that the officers enter the person's house, the moment that their personal property is intruded. For the same reason, we should conclude that a seizure should occur the moment our personal bodies are intruded. And that occurs the second that a bullet hits our body or that physical touch happens. For that reason, it makes sense that the founders would have wanted to provide the fullest protections of the individual liberties of the person. Now, the respondents also claimed that the bullet striking Ms. Torres would have been not a seizure because her movement was not restrained and she was able to continue driving. However, Justice Scalia states that the quintessential seizure of the person under our Fourth Amendment jurisprudence is an arrest, and the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrest, was sufficient to constitute an arrest.
So let me ask a question. If I can ask a question, actually, of Cameron. Cameron, if a police officer taps you on the shoulder, is that a seizure?
Well, it would matter. The thing that we are looking at is the intent to restrain. That is what our definition encompasses. If an officer went up and tapped someone's shoulder with the intent to restrain them, yes, that would be a seizure. But if an officer went up to someone without the intent to restrain them and say shook their hand, then that would not be a seizure under our definition.
All right, that's fair. I understand your definition. How are we supposed to figure out a police officer's intent?
I think that merely going up to a person and shaking their hand does not show any intent. That shows a greeting. If the officer, say, shook the hand and then went to grab them, hold them, whatever, that would be a seizure. Shooting a bullet at someone shows the intent to restrain with physical force.
Additionally, a warrant or some kind of reason is determined by the court would also be evidence to what their intent was.
Okay. You have about a minute left, counsel, if you want to wrap up.
Okay, so the respondents also stated that Hodari D would not count and should not be used as precedent in this case because of a footnote 2 and in the document. Now, this is not accurate because Justice Scalia stated, as in the quote that I provided just recently, that the mere grasping application of physical force with lawful authority is a seizure regardless of whether or not it was successful in subduing the person. Additionally, they also stated that the shooting her in the arm would be not considered a seizure and would have not been something that would have been something that they were allowed to do in the situation. However, most police officers have it as common practice to not fire in a neighborhood or pursue a suspect because that would pose risk to the surrounding area, as a high-speed chase would be very dangerous. So this practice was unconstitutional and it was not very wise on the part of the officers.
As such, we should incorporate the common law definition of arrest into American law.
Okay, thank you. Okay, you guys are out of time. Thank you so much.
Thank you.
Petitioners, come back on. Mr. Seeley, come back on as well. Respondents, I mean, come back onto the camera as well. Okay. Let me be the first to congratulate you. That was spectacular. Truly, that was, I think, the best round we've had all day. So that was excellent. You've really upped your game, all of you. I saw you in your preliminary rounds. I saw you in your briefs, and I've seen you before, and you all upped your game. This was not the presentation I'd expect from a bunch of high schoolers. This is what I expect from law students. And I'm a professor. I can say that. I can credibly say that. What you were doing is not what a bunch of 16 and 17-year-olds are doing. It's what a 25-year-old law student would do. And the way you handled our questions was really good. I also really appreciate how you responded to each other. You brought up the Mace case, and then they responded to the Mace case, and you sort of went back and forth. And you talked about Hodari D, and they responded to Hodari D, and no, it's dicta, it's not holding, and you sort of went back and forth in those cases. Really sharp. I think you all have very promising careers ahead of you in law. If that's what you decide, whatever you do, you'll be great at it. But this is really wonderful, and I'm glad Mr. Seal's here. He's your coach. He does a good job teaching you all. He has several teams this competition. Very happy to see him. But congratulations to you. I could have never done this when I was your age, and I've been close. And I'm just sitting here really, truly in awe of how you put this all together. I know how much work. This was not easy. You guys didn't just wake up on Saturday morning and do this. It took a lot of work. So kudos to you guys. Chris and Jen, anything you'd like to add?
Yeah, I just have to add, I mean, that was awesome. That was really, really awesome. And I think similar to Josh as a fellow law professor and somebody who's practiced and did appellate practice, because that's what I used to do, in so many ways, I loved, and you could tell I was only asking hard questions because I knew you all could answer them. And I mean, we equal protection, and we're tying that into the Fourth Amendment. And, Mr. Rose, you just happened to run into a buzzsaw because I just gave a lecture about the writs that we were talking about 2 or 3 days ago. So I've done all of this research recently on the writs and how that turned into the Fourth Amendment. And I have to say that was amazing because you did such a good job answering those really hard questions. I mean, I can't remember a time in recent memory, and just like Josh mentioned, I could never have done this in high school. There's no way ever. I can't remember a time where I've seen teams work quite like this.
Mhm.
That was really, really, really good, both sides. And Mr. Rose, Ms. Sanchez, I mean, you were going back and forth. You could tell I was pushing both of you. And Mr. Spalding and Mrs. Rose, you could see I was pushing both of you too. I mean, that was very, very well done. You should all be very proud of yourselves. And let me switch very briefly to the briefs. I'm sitting here looking at the briefs and asking questions. The briefs were great. You did an excellent job encapsulating arguments. I can tell you spent a lot of time on them. And as somebody who's done those myself at SCOTUS, I just have to say, you should be very proud of what you were able to accomplish there. I mean, you all did a really great job today.
Yeah, I agree 100% with everything that my fellow justices have said today, my fellow judges have said today. You guys were phenomenal. You were very polished and well-spoken and just prepared, very prepared. And that really, really came through. And now I can see not just that your briefs were well written, but that that you can also speak well on your feet. You could think very quickly, that you knew the argument deeply, and that's so important. And so thank you so much for all of your hard work leading up to today. I hope you feel really proud of yourselves because you did phenomenally.
Yeah, excellent. I really I was so impressed both with your Fourth Amendment analysis of the 14th. I never thought the way before. Like I gotta tell you, I've been studying this stuff for my entire career. I never thought of interacting Fourth and 14th Amendment like that. That was really creative. It was very good. And I gotta tell you, Avery, you guys nailed the writ of assistant question. That was not easy. Like I was like, uh-oh, here it comes. I knew where he was going with it.
That's exactly. I was like, how are we gonna do this? It was
And then you got
great.
nailed it. And also, I know how hard it is because you two are in person, which is nice. I'm glad you're back in school. But with Zoom, you can't always do this, normal. So it's hard to handle. I mean, even like actual courts, if you guys will go to an actual court in Texas or Arizona or anywhere else, you have lawyers on Zoom. U.S. Supreme Court is on telephone, right? So what you're doing is really good prep for like this weird Zoom world we're all living in now. All right. Well, cool. I got nothing else, but you guys are spectacular. If I can ask, I think I talked to Avery and Brooke last year on Zoom after the semester, but do you guys have interest in being attorneys? Thinking maybe law school?
Yes, my older brother is in law school actually right
Oh,
now. He's
wow.
becoming a lawyer, and I'm thinking of following in his footsteps.
Where is he in law school?
He's going to U of A, but he's transferring to a college in Spain right now, actually.
Wonderful. How about you? I'm sorry. I have too many roses on my screen. Cameron, I'm seeing roses.
Yeah, I've considered law school. I'm looking at a lot of different things right now. That's definitely one. After this, at first I took a speech and debate class and I was hesitant about law, but after doing this competition, I'm definitely more inclined to look into that and do some research on law schools.
Yeah, I agree.
Cool. Are there any questions you want to ask of us?
Just a very,
Please, Avery, go ahead.
just a random statement. Okay, Cameron, my brother's name is Cameron Rose. So when I looked at the stuff, I was like, what? Is he coming back for some reason? So
I was so excited to see another Rose in this competition.
Yeah, it's good. It's good to see another Rose.
Mm-hmm.
That's excellent. I'll give you Cameron and oh god, team from Arizona. I'll give you the same offer I gave to Greg's class. I teach a First Amendment class Mondays and Wednesdays from, I guess you're in Arizona now, right? So is it 12:30 there, 12:40 there?
It's 11:41 right now.
Okay, so you're 2 hours back. So it would meet Mondays and Wednesdays from 11:30 till 12:30. If you want to attend my First Amendment class this upcoming week from either Monday or Wednesday from 11:30 to 12:30, send me an email through your coach, and I'd be happy to let you guys join my class.
Okay.
Thank you so much.
Yeah, I'll look at my schedule and I'll see how that works out.
Yes,
Yeah,
thank
and
you.
Avery and Brooke, you're welcome as well. Greg has the information, but you don't have to participate. You can just sit and watch. I'll give you the readings. I won't call on you unless you want me to. I might. You know what? Screw it. I'll show my students how it's done, and then you'll see that your answer is just as good as this may be a good controlled experiment. I may cold call my high schoolers, and I won't even tell them who you are. I was like, oh, these are interested in law school, right? I won't tell them who they are. You can pass for law students, right? Whatever.
That's particularly true with 3 classes left. Those law students may not be as prepared.
I tell you what, you give us the reading, anybody who shows up will be prepared.
We're gonna make it happen. All right, email me later, okay, Greg? All right. Is there anything else you want to ask us, either team? These are just really strong performances all around.
We just wanted to say thank you so much for this opportunity, and thank you for listening to our arguments. We had a really enjoyable time doing this.
Yeah, this is a lot of fun. I really appreciated the opportunity. It was really cool.
Yes, thank you.
Okay.
And oh no, go ahead.
Chris, that's you.
I was just going to add one thing that I've mentioned to a team previously, which is, so you do have a panel of 3 lawyers, but I'm the first person that would note that one of the great things about what you've just done and learned is, even if you don't end up being an attorney, which I am the biggest proponent of doing, the ability to do research, to do writing like you've done with the briefs, to be able to think on your feet. That is a very, very hard thing to do, and to be good at managing questions, dodging questions, reframing arguments. the skills that the four of you just displayed, there's no question in my mind, as somebody who has had the chance to teach high schoolers and undergraduates and law students and other graduate students, that serves you in any profession. So even if law is not necessarily where you're going, I promise you that we need more civically virtuous people in our world like yourselves who are able to do that in any profession, no matter where you're thinking of going. The skills that you have just displayed work and make a world of difference. And so that's one of the things that I'm just so impressed by, seeing. And I'm also the same as Josh. I would be the first that would probably call on you in my class. And there's no question in my mind that my law students say, how did a high schooler know that? I don't know about the writs of assistance. What's that? What are you talking about? And they would start freaking out that a high schooler knows more than they do. So you should be very proud of all of yourselves for being able to manage things that I know for a fact would be fun at minimum when it came to a law school class.
All right, cool. Anything else in your minds?
Is there any way that we could receive a copy of this recording? Is that something that's possible?
We'll be
Just
on
so we can.
YouTube. It's going to YouTube on Monday.
Perfect.
Thank you so much.
Yeah, no, and we're gonna put. I'll send the score sheets around on Monday, so you'll see we have a very detailed rubric, which I think I sent around, so you'll have very detailed scores. But I think we're gonna advance 4 teams. That's our plan, like a Final Four type style. So we had 24 teams in this round. We're doing 12 teams today, 12 teams tomorrow, and we're gonna advance 4. So it's tough, but we wish you all the best of luck. This is really fantastic. All right, thank you all. If the students and coach can sign off, and the judges can confer for a few minutes before our next round begins, I'd be grateful.
Thank you.
Thank you. Here, guys, and I'll turn off the recording.